Alex here with part 109 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0, if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I'd like to glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. So this is the hearing. This is a hearing that I remember having very significant anxiety going into. I remember quite a few sleepless nights. Mainly it was all of the orders denying, and it didn't help to have the judge's order imposing sanctions. So I felt like I was going into the lion's den at this point. I felt like it was crystal clear that he was angry that papers were being filed. I felt like in the documents it fell on deaf ears that I had been trying to help my son, and so I imagined that at the hearing he wouldn't really care about that either. He was going to basically continue what he was doing all the way through the filings at that actual hearing. And it's tough, guys. It's tough to go into a hearing knowing you're going to get chewed out even though you don't deserve it. And that's just one of the issues that we have with our court system in this country. There's just nothing you can do about it. If you don't go, it's going to be a whole lot worse. So it's better to just go and go in there with the mindset, how do I preserve my arguments for appeal? How am I going to, what are the things that I need to say so that I can file an appeal? That's the best way to go into a hearing. Preserve everything that you've raised in the papers and make sure that you say just enough to preserve the arguments that you want to file an appeal on. You don't necessarily have to argue with the judge, yell at the judge, and you don't at the same time necessarily need to cow in fear. But you do need to say certain things to put those specific things on the record so that if you want that opportunity afterwards, you can file an appeal. And this is of course me saying something in hindsight. I didn't really think this way back then. I just thought, oh, this is not going to be good. I haven't looked at this video ahead of time, so for all I know, it's not as bad as I think it's going to be. And with that being said, let's go ahead and take a look at that hearing.
Court of the State of Nevada is now in session. The Honorable Chuck Weller presiding.
While you're standing, with the parties each please raise their right hand, face the clerk, and be sworn.
Do each of you solemnly swear that the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Have a seat, please.
Thank you.
We're on the record in the case of Alexander Falcone versus Monica Farrar. Ms. Farrar is present in the courtroom with her attorney, Ms. Berning. Mr. Falcone is present in the courtroom without counsel. This is FV 08-03200. I'm talking in a clipped manner because I don't want to take any time from you. We have 2 hours. The time will be split evenly between the parties. When you've used your whole hour, you're done.
Okay, so this is a indicator that this is an evidentiary hearing. I know I wasn't sure about it for some time, and I kind of went back and forth, especially given the fact that it was just set for 2 hours. Guys, 2 hours isn't enough. It's just not, I just can't get my head around that being a realistic amount of time to modify custody under any circumstances. It's really hard for me to think that this was actually taken seriously by the court. But the thing that I want to mention is when you don't have an attorney, sometimes stuff like this can happen. If you are sitting a hearing and you get some kind of input in that, you should ask for at least 4 hours, and that's if like it's just he said, she said with just maybe a witness. If you're looking at more than one witness, especially if there's an expert involved, that's going to be a day, usually multiple days, especially if it's multiple witnesses. The reason that I say that is because sometimes there's an attorney who tries to drag things out and it seems like something won't take very long, but then it takes forever. Anyway, last thing I wanted to mention before I go into my opening statement, because I'm sure it's not going to be the way that it's supposed to be, even though I haven't seen it yet. Opening statements, guys, don't take this as an opportunity to argue your case. Take this as an opportunity to tell the court what you intend to present. So that's one of the distinctions that a lot of attorneys or non-attorneys don't understand, and they try and just sort of speak to the judge face to face. But that's not really the point of an opening statement. That comes later on when you're actually getting evidence in front of the court and testimony, and that also can be addressed, of course, at the very end when you go into your closing arguments. But opening statements should be something like, Your Honor, I'm asking this court to modify custody, and here's why. Number one, all these absences have been racked up. Number two, she's deliberately sabotaging the child's education. Number three, this is going to be proven using this, this, and this. And that's it. Your opening statement is done. It's not uncommon at all for attorneys to waive it because it doesn't really have any impact on your case. And sometimes it can be used against you because it'll tell the other side what you intend to do. So sometimes by waiving your opening statements, the other side isn't 100% sure as to what you intend to do. So I have seen attorneys actually quite often waive their right to an opening statement. And one more thing that I wanted to mention is try to understand that if you are going to give an opening statement, you don't necessarily have to go into all that detail at that point. Sometimes people feel like, here's all the proof. No, it's okay for you to say, I'm going to prove it with photos, and that's it. You don't have to go into the photos at that point in time. You can do that when you actually get into your presentation. And it's just one of those things that sometimes non-attorneys get totally bewildered with because they don't know how it works. And it really is just a very quick, very short, unless you're in like a murder trial or something. I guess some of those opening statements can take a while. It's sort of telling the judge, and if there's a jury, you can think of it that way as well, telling the jury, here's what I'm going to show you, so keep an eye out for it because I'm going to show it to you. And I think with that being said, let's continue on into the hearing.
Okay. Sir, do you want to make an opening statement?
Yes, please. I filed a motion to modify custody initially because there were problems with Monica not taking Army to school. His teacher was also telling me at the time that there were a few concerns with regards to how she was telling them things about her court cases, and she had, this had sort of gone on for about a year. We actually postponed his education because of some of these issues, and they were still happening. So I didn't want to go back to court, so I filed a notice letting her know, and I filed an affidavit from the teacher with on the record, and I gave it to Ms. Berning so that they could see that these were problems. Within like a week or two, I got another call from the school saying there were 3 more absences, and I believe at that point there were 7, and once you get to 11 absences, the child is automatically discharged if those absences are excused. And at that point, I'd been informing her that there were procedures for when Army can't go to school. You have to let the school know if he's sick or if you're going somewhere, because they will excuse those absences and he won't be discharged. So after all that, I filed a motion, and immediately her conduct started to change after I filed the motion. At this point, she's always taking him to school. She's turning in his homework. The teachers are telling me everything's much better than it was before. So we've actually been very close to settling this and just vacating the hearing entirely. The only problem is there are a few minor issues in the motion that haven't been addressed yet, like the homework itself. Right now, she's basically taking the packet home and turning it in and doing it all. I'm not really a part of that. And the absences, I was hoping that we could, now that we're here, limit like maybe each parent to only taking Army on a vacation while school is in, maybe once or twice, when school's going on, because those absences do accrue as unexcused absences, and I don't want that to be a problem in the future with 5 or 6 or 7. The main thing I'm seeing is I keep having to come back to court because anything that isn't explicitly in an order sometimes isn't construed, in the best interest of Army. Sometimes.
Okay, I wanted to stop here really quickly because even though this is what I'm arguing to the judge right now at this point in time in January of 2013, I have since changed my mind about this approach. Watch my video, Gray Areas. I cover the problems that I'm discussing in this hearing in that video. Please also take a look at my video, Behavioral Orders, because that goes into the other part of that coin, which is to try and control my ex's conduct. And then the last thing I want you guys to do is, if possible, take a look at the video, Many Fine Lines, because that's the video that actually has what I think is the best approach and the best advice for dealing with this kind of problem. I'm trying to get the court to say, hey, Monica, don't do these things. But really, this is a best interest problem. And the way to protect the child is not to control that parent, because the court's not going to be involved all the time. And this particular judge doesn't want to be involved all the time. Instead, what the court should do is deprive her of custody and shift that custodial award over to me. And it sounds bad to say it now, but until you get to the end of this series, you won't see why it is that I reached this unfortunate conclusion. And of course, I wanted to mention one more thing, is by not really reaching this conclusion, what you end up getting stuck in is what I talk about in the video, best interests of the parent.
I know we disagree, and I'm not trying to control her or anything. I just worry when it gets to the point of him being kicked out of school or severe consequences like that, or me being completely excluded from the homework. That's my main concern. The last thing I wanted to say is she did try to work with me on the homework in a way. She asked the principal or the teacher if she would make an extra copy of the packet and give it to me when I go pick him up on Thursday. The problem is it sort of entangles the school in our problems when I think we could handle that ourselves, either by exchanging the packet when we pick him up or drop him off, or maybe just unstapling the last 2 sheets and leaving it in his cubby. I don't really want to make the teacher feel bad because, when I go pick him up on Thursday or Friday, she's busy, there's kids running all over the place. I don't want to say, hey, can I get that extra packet? It really makes us stand out as the problem family, and I don't want them to see us that way in the future.
Okay, guys, it is absolutely inappropriate for third parties to take on the burdens of your high conflict child custody dispute. One of the red flags of a high conflict ex is they will try to rope other people into the high conflict child custody dispute. And that's what my ex was doing. She basically said, okay, fine, you want the homework packet? I'm going to make the teacher make you an extra copy. High conflict parties love to rope in everyone else, doctors, nurses, school, anyone that they possibly can burden with the high conflict child custody dispute, they'll do it. They get a sense of satisfaction out of it. It's really sick because these other people, number one, don't want to be involved in the dispute, and number two, they will think of you as the weird family because you're the family that they have to do extra things for. In my honest opinion, if a parent cannot co-parent without third parties getting involved in the child custody dispute, that parent needs to be deprived of custody. That is such a terrible thing to impose on third parties. This should be very obvious to any judge. I don't know what this judge is going to say about that. Hopefully he agrees. I'm pretty sure he does because he orders her to exchange it. But this isn't one of those things that's kind of like slightly in my favor. This is one of those things that is obvious. Do not require third parties that are trying to take care of your child to do extra things for you because it's a dysfunctional situation. And if that is not something that can be accomplished, then the court needs to get involved and do something about it. It's too bad that the legislature hasn't, enacted some kind of statute about this to make it sort of a mandatory loss of custody, because in my opinion, I feel very, very, very strongly that third parties who are there to treat your child should not be burdened with any of this nonsense. It's so completely inappropriate to me that that's just one of those things that is an absolute red flag.
I believe that's my...
You don't want the school to have an accurate picture of who you are?
I want us to be able to handle our own problems ourselves. I don't want us to say, hey, we're in court, so can you do this, and this extra? When we, if we couldn't deal with it ourselves, fine, but something like, the homework, we could, on our own do that. We don't have to force them to make extra copies and do all that. If the court's going to order that, okay, I'll do it, but anyway, for the most part, those are just a few of the minor issues.
Ms. Berning?
Your Honor, I received from evidence that we would put on if we and I think that Mr. Falcone would acknowledge is that he said this in court, that things have improved. There was emails from starting on November 27th, another one on December 12th, another one on January 7th, another one on January 21st, all of which said that he was either going to drop the motion or he was, could we work out that everything was going fine in school and that the problems have seemed to have evaporated, but could we continue this for a couple of months? And this is my concern. One is that I don't think that, and I think Mr. Falcone has acknowledged that neither prong of a motion for change of custody has been met, that a change is not in Army's best interest, and that there's no substantial change of circumstances. And I think he's acknowledged that within emails and also in court today. The issue, basically how the school started for Army on August 16th. He filed with the court a statement from Mrs. Durio on August 23rd. Not even 1 week had Army been in school when he was getting an affidavit from a teacher to set up some sort of litigation.
So this is one of the things that conniving attorneys will do. They'll try and distract the court from the material, and they'll try and draw the court to something else that doesn't look good. They'll say, you're filing too many things, so they'll focus on the number of filings. They'll say, you're filing something too soon or too late, so they'll focus on the timing of the filings. They'll do anything that they can to get the court to not pay attention to the contents of the filings. In this particular case, if a teacher says that a parent is deliberately sabotaging a child's education, that is the issue that is alarming and should have the court's attention, not the fact that the papers were filed within a specific time frame or the number of papers is too high. And again, this is one of the things that you have to worry when it comes to attorneys who are going to employ win at all costs mentality. If you haven't seen the video, win at all costs, please watch it. Is when you're dealing with conniving attorneys, that's one of the ways that they actually are able to enable the abuser to continue to abuse the child, is by taking the court's attention off of the actual child abuse and neglect and pointing to things that are actually immaterial or don't matter. And it actually does work depending on the specific judge. This specific attorney is, as I've mentioned in previous videos, she's taking advantage of this particular judge's prejudices. She knows that this is a work it out judge. She knows that it's a wing it judge. Please watch my video, Wing It Judges. She knows that it's a judge who doesn't like people who file papers, and she knows that it's a judge who doesn't like people who file papers right after, litigation is over. And so she's taking advantage of all this particular judge's weaknesses, and she is exploiting them. This is very common with attorneys. They're in front of judges all the time, and they begin to figure out how those particular judges work, and they will figure out what those judges' weaknesses are, and they will exploit them. And that's one of the ways that an abuser can win a case, is when they get an attorney like this and they employ these conniving tactics. So let's take a look and see what this particular judge says. I would hope that he focuses on the fact that this is an actual problem, but I have a feeling that her attempt or her tactic is going to work because it's worked in the past, and something that works in the past generally will continue to work into the present and future.
That's concerning. When we look at his motion, and once we look past the change of custody, the items that he speaks about that he wants to have the court rule on are, in the words of Shakespeare, much to do about nothing, I think.
How many days did the child miss school with your client?
I think there was 7 all total. Also,
that's a concern to me.
I would present an email from Mr. Falcone, which states that he finally figured out what the school's absences policy was on December 17th. And that basic absence policy allows for both parents to have time with Army outside of the school setting in kindergarten. So as far as the absences go, the absences that I would have that we would talk about basically were, there was one family vacation that had been pre-planned.
Hey guys, really quickly, I just wanted to stop and say that this is not normally how a trial is formatted. The judge appeared to want to start it out as a standard trial format when he said opening statements. You're limited to an hour and an hour. I do want to say that when I went into my opening statement, I went way out of boundaries as to what an opening statement is. And I think that, I'm not going to say that this attorney is doing anything suspicious at this point in time. She probably just went with it and decided, okay, well, if we're just going to wing it, we're just going to wing it. And I think the judge, same thing. I don't think anything, I guess you could say, damaging to me is occurring at this point in time, with him just kind of going along with it as well. I just wanted to make it clear to my viewers that this isn't typically the format of a trial, and even though in our case we've just wandered off into let's just kind of speak to the judge and present our case, I do want to at least let you guys know to not expect this to be how trials are formatted in your case, because you might find yourself shocked when it doesn't happen in your case. Instead, what I'd like you to do is watch my video, Trial Format and Trial Format Revisited. Again, nothing shady going on here in my opinion. I understand that they've, both the attorney and the judge have kind of just transitioned into this let's just wing it sort of approach, but I do want to at least let my viewers know that even though the judge intended to start it off formatted as a formal trial, at this point in time we've kind of just gone away from that.
that they allowed him to go on.
Who's they?
Excuse me, the school. The school knew that my client was taking Army for a trip down to Southern California to see family. Isn't that correct?
I wasn't going to Southern California, but yes.
Yeah, so they knew ahead of time. Every other absence that Army had to do with either, there were 4 absences, there was 3 absences, I believe, when he was sick, and then there was 1 absence when my client was sick and couldn't get Army to school because she was so sick and couldn't find somebody to take him. So that's really the instance of it. As far as the rest of the time and the absences, he's clearly within the range where he's not going to get kicked out of Coral Academy. The other thing I would tell the court is what Ms. Farrar has tried to do is to work with Coral Academy. She has no plan, and you'll notice the court, we didn't come back in May to reconsider the issue of his going to Coral Academy. In fact, Ms. Farrar, Ms. Durio, who was the initial teacher who did the affidavit, was no longer there at school after about a month. So then the new teacher is Miss Alameda, and that teacher has done everything to work with Army. And basically what they have for a schedule is green cards, and Army collects the green cards, and then he's able to go take them and get a prize. Before this time, he was getting red cards with Ms. Dury or yellow cards, and now he's getting all green cards. He's doing very well. So as far as the absences go, I think that even Mr. Falcone would say that that he's not in any range right now where he's going to be out of school.
Okay guys, number 1, be very careful about attorneys who try to speak for you, especially your opponent's attorney. Like, that should be obvious. A judge shouldn't allow an attorney to speak for their opponent's client. I don't know why this judge isn't doing anything about it, but that is something that is severely inappropriate. The other thing is, if it does happen to you in your case, when you get the opportunity, make sure that you correct that statement because you didn't say that. And then the last thing that I wanted to mention to you guys is arguments of counsel are not evidence, nor do they establish facts. That's one of the quotes from the Supreme Court of Nevada. And we are technically in the middle of a trial here, and it's not appropriate for this attorney to testify on behalf of her client. The Supreme Court has stated this, and they have reversed decisions that have been based on the arguments of an attorney. So this is something that if I had an attorney, they would object to, but I think if I had an attorney, it would go into the standard trial format. So it confuses things a little bit to just go into this wing it format. But this attorney is doing a little bit too much. She should be asking her client the questions so that when her client answers those questions, they are submitted to the court as testimony, which is evidence. The attorney herself should not be speaking for her client in this manner because that is the attorney trying to turn her legal arguments into evidence. The other thing that I want to mention is this is one of the things that was instrumental in enabling my ex to continue to abuse our child. Had the attorney not spoken for my ex in circumstances like this where it's inappropriate, my ex would have spoken directly to the court, and it's possible that some of the issues that she had, some of the mental health issues, some of the emotional immaturity issues that she had would have been more apparent to the court. But by this attorney speaking for my ex during this specific trial, which is not appropriate, she was able to sort of conceal or sweep under the rug some of the major issues that my ex has. As I go through these videos, it becomes more and more clear to me why our son had to suffer for so long. One irregularity after the next, and one misfiling after the next, and little by little, surely you can see how the legal system, the judges involved and the attorneys involved, can actually facilitate and enable child abuse and neglect.
The other thing that has happened as far as the homework goes, Your Honor, is that when Mr. Falcone, the reason that Ms. Farrar took the packet of homework and asked the teacher to provide a packet, which Ms. Alameda is very willing to do for Mr. Falcone, is twofold. One reason is so that Mr. Falcone actually sees the full packet of what Army's doing for the entire week, which is very helpful for both parents. The other thing is that what had happened before was that she would do the homework, Ms. Farrar would do the homework on Monday, Tuesday, Wednesday with Army, and then hand the whole packet over to Mr. Falcone. He was to do the homework on Thursday, Friday, and then turn the packet in. Well, the packet wasn't getting it wasn't getting turned in. Army's performance was suffering because of that. And so Ms. Farrar, to make sure it got done and that things were going fine, does his homework with him to make sure that happens. If she can, she goes into Thursday and Friday. But then when she's able to get him when they make the exchange and Army comes back to her before school on Monday, then whatever assignments he hasn't completed, they do at that time, so he's caught up. And that's been the reason. We believe that Mr. Falcone, in filing these motions, and if we look at what he initially asked for in his motion, he wants each person to purchase their own school supplies. Ms. Farrar's done that. She's purchased a school uniform which consists of a shirt with a logo on it. She does respect the staff at Army School, and it works very well with his current kindergarten teacher. She has never disparaged Mr. Falcone at school, and she does address the disciplinary issues. Parents, I think, have different takes on what needs discipline and what doesn't. But I can tell the court, and I make it an offer of proof.
Okay, so what the attorney is doing when she's making an offer of proof is she is clarifying that her statement, while not evidence, is what would become evidence had her client had the opportunity to testify. So she's telling the judge, hey, if you want to talk to my client and have her testify, she will testify this particular thing. And again, all of this testimony is basically leading, even if my ex does testify, and I'm not sure if she does, I think maybe the judge just asks her a few questions. She's basically been led. My ex's attorney basically led the witness this whole time through by giving her just this colloquy about what's going on when those particular statements should have been made as testimony with a standard sort of cross-examination process. And that could be something that I could have objected to, but I really didn't know how any of this worked. I was completely ignorant. So I guess going back in time, had I known, I could have said, Your Honor, I object to this. I want to question her on the stand. I want to cross-examine her on the stand, things like that. And of course, it would have probably irritated him because he didn't really want to deal with this anyway. And I can tell by the fact that he set this hearing for 2 hours. But that would have been the more appropriate thing. And then I could sort of try and poke holes in her statements, and I could sort of see what her actual genuine responses would be to all of these different things that are happening in court. I could have exposed some contradictions, but I didn't go in there with that mindset, and I didn't plan, and I didn't set this sort of process up. Guys, when you're going into a trial, you need to plan for a trial or an evidentiary hearing. You have to plan for it. You have to sort of get in your head the questions you're going to ask. You have to outline the issues. You have to sort of anticipate what your opponent's going to say so that you can kind of counteract it. And it doesn't seem to me like I did any of these things. So I certainly didn't help my own case. But the point of this channel is to help people who just have no clue. And me, by myself, back then, without any support, I had no clue. I was picking things up along the way, but I didn't have the total 100% understanding. And even now, I don't have that. I mean, I can't say that. I know that people trust my knowledge because I've gone through this for so long, and I have, of course, the non-attorney perspective, which is very valuable to my viewers. But even now, I don't have the three-dimensional, full, comprehensive view that attorneys will have. Attorneys who have hundreds of clients a year, attorneys who are going into court all the time, who file papers all the time. They're always going to have that very deep, thorough understanding, not necessarily the same as maybe another attorney who's of better quality and higher caliber, but for the most part, they have that advantage of going to work every day, 9 to 5, in this field, and that comes with picking up a lot of these little details.
That I've seen Ms. Farrar with Army, and she uses a assertive discipline program to basically send him in a timeout when that's appropriate. She's not trying to change the school. She's not trying to do anything but make sure that her son has a good environment. As the court knows, this case has been very litigious. I'm on volume 5 of pleadings in this case. And I think that by Mr. Falcone's own admission, for Army to be doing well in school is proof in the pudding that we don't need all these additional rules.
Okay, that is extremely disingenuous because the filing is what triggered the change in behavior. If I didn't file, that behavior would not have changed. 100% I am for sure convinced that our son would have been ejected from that school because she would have continued to accrue absences. This judge should know better. That attorney should know better. Had I not filed, that change in behavior would not have occurred. And I think that's one of the things that really lit a fire under me to reach the conclusion that these judges and attorneys don't really care about what's best for our kids. Simple, obvious, logical things like what I just mentioned, they either do not understand or do not even want to try and understand. This is the perspective that I picked up at that time. It's different now that I'm here in 2020. I've seen a lot of other judges in action. I do think that a lot of other judges would have called out that attorney and my ex, but a lot of other judges isn't necessarily all other judges. I think that there are some judges who still, they have a specific conclusion that they want to reach, and if they have to be illogical to do that, they will do it. But at this point in time, in my particular case, with my experience with my judge, I felt that this was such an obvious thing that this judge should have easily understood, and that he just didn't, because if he did understand that, he wouldn't have sanctioned me. He would have told my ex's attorney, I'm not going to sanction him because for all I know, the motion he filed is what caused your client to take your child to school. This is not a completely way out there idea. It is very, very normal. It is quite common for a human being who is faced with a consequence to change their conduct. And that same human being who, not confronted with that consequence, would not have changed that conduct. This is extremely obvious stuff that any ordinary, simple person can understand. If you tell somebody, I'm going to do this to you if you don't comply, not necessarily every single time, but they're going to consider it and they may change what they're doing. Everyone knows this.
The court doesn't need to order both parties to abide by the rules for Washoe County School District. I don't think that's a necessity, and especially when Army is doing so well.
Yeah, our son was getting suspended from school, D's, F's, written up, but that doesn't fit her narrative, so she's not going to tell the court that.
But my client would be, of course, willing, if the court were to enter an order like that, my client would agree with that. The reason, Your Honor, that we could not agree in this case and settle it before coming to this hearing was that the actual language of the documents that went back and forth between us, there were things included that were inappropriate, I believed, to deal with the issues in the case. And, Your Honor, for those reasons, I had asked the court to deny Mr. Falcone's motion and to also enter an order and take control of the case because of the number of pleadings that Mr. Falcone files. We would ask that the court, under Blackjack versus Las Vegas Municipal Court, that the court take control of this case so that Mr. Falcone or Ms. Farrar, prior to filing any motions in this case, would have to petition the court with a one-page document explaining why they need to file that motion.
Okay, so this is one of the things that I was going to say that I think she knows what she's doing is wrong, and she is basically violating our constitutional rights on purpose. But in hindsight, I really don't think that this attorney understands what she's doing. I don't really think that she knows what she's asking for. What she's asking for is a vexatious litigant order. And there's all sorts of things that are wrong with the way she's doing it. Number one, the Supreme Court of Nevada takes vexatious litigant orders very seriously. They have a four-pronged test that the judge has to comply with before entering a vexatious litigant order. And if those tests are not complied with to the satisfaction of the Supreme Court, and I mean to the satisfaction of the Supreme Court, they don't bend on this, they will overturn that judge's decision. Vexatious litigant orders are one of the things that are the most sensitive to being overturned on appeal by an appellate court. The second thing that she's doing that's inappropriate, well, there's actually another two things that she's doing that's inappropriate. It's highly inappropriate for her to ask for a vexatious litigant order without filing a formal written motion. That is way beyond the realm of normal. And it might even be something that's considered plain error by the Supreme Court, which is an error so obvious that you don't even have to preserve it. The second thing, or the third thing that she's doing that's inappropriate, is she's trying to extend this to her own client, which you can't do. Vexatious litigant orders only work on non-attorneys. The attorney can never be subjected to a vexatious litigant order. The reason why is because an attorney who is a vexatious litigant is an attorney who won't be an attorney anymore. The state bar deals with that problem. If an attorney is filing papers and pleadings that are so meritless that they reach the level of that attorney being vexatious, the attorney will be fined, the attorney will be suspended, and in the worst cases, the attorney will be disbarred from the practice of law. They don't police attorneys using vexatious litigant orders. In fact, an attorney isn't a litigant. And my client, or my ex, or my ex's attorney, I guess in a way, technically, she could be subjected to the order, but even if she was subjected to the vexatious litigant order, it would not impose any restrictions on that attorney. If somebody has a vexatious litigant order, they can still hire an attorney, and that attorney is not bound by that order. That order is just for their own litigant, or for their client, I guess, theoretically. And that attorney could just go ahead and start filing things. They don't have to deal with that order. That order doesn't apply to them. It's outside of the scope of the power of that order. They can, just act as an attorney. So a whole bunch of things that this attorney is doing don't make any sense at all. In fact, I've never heard of this blackjack case. The case that discusses vexatious litigant orders is a different case. I don't have it off the top of my head. But if you guys want to know more about it, please watch my video, Vexatious Litigant. I think it's Vexatious Litigants or something like that. Because in that video, I go into some of the details as to how this works. Luckily, this judge knows better and denies her request.
And Your Honor, I believe that would be a good course of action. It might take some of the litigation out of this case. And the site what I'm referring to is Blackjack Bonding v. City versus Las Vegas Municipal Court, 116 Nevada, 1213 in 2000. Your Honor, we're more than halfway through, or almost halfway through, Army's school calendar for this year. I don't believe that the court needs to be the micromanager of the case for these parties. It seems to me that we've been able to resolve the matter, that Army is doing very well, and that there may always be friction between Mr. Falcone and Ms. Farrar. It does Army absolutely no good for both of his parents to come in here. There have been other things that have occurred that Mr. Falcone has done to exclude Ms. Farrar. He has, on Halloween, he was getting the notices and not Ms. Farrar, and he was not passing those on to her, and that neither was the school. And so she dropped Army off at school not knowing that it was the day for costumes. When she came back, she found that Mr. Falcone had spent the day with Army.
Wait a minute. Your client couldn't find out that the day was the day for costumes? She was dependent upon somebody else to tell her?
They gave the notice to Mr. Falcone.
So why didn't she find out?
I found out when I got there.
She found out when she
Why
got
didn't you find out before?
Because the way they notify you is they hand you pieces of paper with all the information. And she told me when I dropped Army off, I was like, everybody's in costume. I was like, I didn't realize it was costume party. And she said, I gave the notice on Friday.
Let me talk a little bit. Let me take over for a little bit.
Sure.
First of all, in relation to your request that I take over control of this case under Blackjack, it's not fair to come into the courtroom and give a citation and ask me to an order. He's got a right to have a notice of your request and a due process right to contest that. If you want that, you have to file a motion.
I will, Your Honor.
She doesn't.
Okay, as far as Mom not knowing what's going on with the school, I don't buy any excuse that Dad didn't provide her with the information. You have as much access to the information at the school as does Dad, and if they only hand out one piece of paper because they don't care if you're divorced or what your status is, it's your business to find out. If you take your little child to school and everybody's in costume and yours isn't, it's hard to blame anybody but you for that. Okay, your poor child. I'm sorry your child suffered that. It's your obligation. as a parent, to find out what's going on at the school.
Can I respond
Okay,
to that?
the policy of the Washoe County School District is to treat parents equally. I have a suggestion on what to do about this homework packet and this information about school. One is that you should both have an obligation to be in touch with the school. If you don't think you're getting paperwork, okay, call somebody. You know, Halloween's coming up, Christmas is coming up. You went to school as a child.
No, I
Things
didn't.
happen. You didn't go to school as a child?
No, I didn't. No, I didn't. This
Okay,
is my first
all right.
experience.
A lot of people went to school as a child, and most people in our culture know that around holidays, schools have events.
Well, we didn't
Take some
celebrate that.
responsibility and find out about them.
So you can hear, this is like the second or third time her attorney's told her to stop talking. Her attorney knows. Her attorney knows that if she talks, it will become abundantly clear that she has mental health issues. This is the kind of stuff that makes my blood boil, because the court and the legal system are to blame for the abuse that went on in this case. The information was there. All they had to do was comply with the law and allow that information to bubble up to the surface. Instead, we have an attorney who sweeps everything under the rug, a judge who basically allows that attorney to get away with everything, including not allowing her client to testify when at an evidentiary hearing, or at least not asking about it, where I think many other family division judges would want to hear from the parent. If you are concerned about mental health issues, one of the quickest ways to get at least a suspicion that there might be an issue is to talk to that litigant, or at the very least have them examined on the stand in open court. To continue to allow attorneys to speak for their clients and put words into their mouths is basically asking for these disasters to occur.
A thought that I have that might make life easier for the two of you, I don't know if it'll work, is instead of the exchange that you currently have, switch to week to week. If you switch to week, you'll each have a homework packet each week. At the end of time, if one of you isn't as responsible as the other in relation to school, it'll be clear.
This is a great idea. I have to say, this is one of the best ways to reduce conflict in high conflict child custody cases. This judge's suggestion is pure gold. It's on point. It's 100% the best possible thing to do. If he would have done this, that would have drastically reduced the issues. It would have solved so many problems. But my ex is going to oppose, and she's going to use a pretext or a plausible explanation. But deep down, the real reason that she's going to oppose is because it deprives her of the opportunity to perpetuate the conflict. And that includes additional visits as well as additional exchanges, including items.
You know, 1 week the child does well, is prepared, has homework done, does well on exams. The next week the child isn't ready. So it might make life easier if you were to switch to a week-to-week schedule as opposed to the schedule that you've got in midweek. So I throw that out for your consideration. As far as school absences and what their policy is and how close you can get to the limit without having the child thrown out of school, I understand that. I guess that's one way of measuring yourself as a parent. I will tell you that as long as I'm the judge in this courtroom, taking days off for vacation is not acceptable. I suppose a death in the family would allow it, but taking days off for vacation is not acceptable.
I like that better.
Those are school days. Okay, schedule your vacation at some other time. Those are the thoughts that I have. I don't know if that will help anything in resolving this case, because I hear that the two of you want to resolve this case. I haven't seen an affidavit from you on attorney's fees, and I don't know where you are in relation to that, whether you intend to pursue it or you're letting it go, or...
Your Honor, I'll be filing the affidavit.
Okay, well, why isn't it, I mean, that was of some time
I
ago. We're in
apologize.
court today. Why isn't it already filed so we can resolve that?
I apologize, Your Honor. I had, over the holidays, an emergency with my family, and so I apologize to the court for
Well,
that.
I just don't want anybody to
I
have to come
understand.
back.
I understand, Your Honor. And I apologize for it. I will present it to the court. The fees that I listed, I will comply with the standard that the court has and do an itemized list. But it will be the same amount that I listed
Well, it's
within
just
the affidavit.
Brunzell and Wilfong, you know,
Exactly.
those cases require an affidavit. When
Yes.
did I issue that order?
Oh, quite a while ago, Your Honor. It was in December.
All right, let's talk about that some more in just a moment. Does either side think that switching to a week-to-week schedule might be a better idea
Get a
to
lot.
reduce the conflict between the two of you?
Changed my whole life around the schedule.
Wait a minute. Can I just
Of
have a
course.
moment with my client, please?
Of course. You can step out if you'd like.
Thank you. Please step out for a minute. Your Honor, in speaking with Ms. Farrar, she believes that that she and Mr. Falcone can make the homework situation work out. That's really the only rub, and that to change to week on, week off is not necessary. The one thing that would do to the schedule, because of her schedule and Mr. Falcone's schedule, it would actually put Army with a babysitter more often when he's with both parties. Right now, she's able to be totally off with him, and she works at the VA federal job on Sunday, Monday, Tuesday.
Neither side has asked for it, and I'm not going
Right.
to impose
So-
it on anybody, but they could do a right of first refusal if the babysitter's an issue.
Right. But I think then that would create more contact. I think the schedule really, if we could have the schedule remain and have both parents just responsible for turning in the homework on the days that they have, on the school's days that they have Army, I think that would solve the problem, Your Honor.
Okay?
My client's willing to do that.
Okay. So they tell me that I should deny your motion, that you haven't proven anything, and that I shouldn't enter any order today at all, except one were to limit your ability to come to the courtroom.
Okay. They mentioned that that I was leaping to the court.
I'm sorry, I didn't.
That I was leaping to the court just willy-nilly. Apparently, that I love going to court. Apparently, according to them, if that was true, I wouldn't have sent her countless emails when all these issues were popping up. I wouldn't have filed those notices beforehand. And if I really wanted to just take custody of Army, I would have just not done anything. Waited until she accrued 3 more absences, because she would have. He would have been discharged from school, and then I would have come back saying he's been discharged from school because of problems.
Sir, what do you want me to do today?
I was wanting you to order. Hold on, let me get that. Sorry, I wrote it down or typed it out.
This is actually a really common problem with non-attorneys, including me, as you can see, is it's hard to be mean, almost like. It's hard to tell the court, I want you to order my ex to do these things. And it seems like the approach most of us take is, here's all the problems, tell us what to do, but make sure that what you tell us to do is favorable to me. And it's not really the best way. I mean, it's not the way that court is typically approached at all. If you go outside of the family court system, that isn't how court works at all. And it really isn't the way family court is supposed to work, but the judges kind of adapt to this particular problem. Anyway, you need to clearly state, here's what I want you to do. I want the court to order this, this, and this. And I want the court to order those 3 things because of this reason, and this reason. You have to get past this feeling of, I'm going to sound like a bad person. And you just have to accept that this is what you're here for. This is how court works. You've tried to work it out. You've sent the emails, you've talked, it didn't work out. Now that you're in court, you got to shift the way you think. You got to shift the way you act. Don't concern yourself too much with how you look. I mean, to a certain extent, optics matter. But when you get to the very end and you're like, here it is, I need an order, you just have to suck it up and say, these things, they're not the best thing in the world, ideally, but our family has issues, we have problems, we can't work things out. I need you to order these things, and this is why. And state it clearly, concisely, and cite to the evidence. And I really wish that wouldn't have been a problem that I had, but just like most other people that go into court representing themselves, that's a problem that I had.
I was wanting you to order. I was first going to want you to order that there will be a limit of 2 absences while he's in school, but I prefer 0. I like that better, because if you don't order that, it is going to come up again. I'm not going to be able to do anything about it. And I would like you to please order that we facilitate the submission of Army's homework between ourselves without involving the school, if possible.
I don't understand what you're asking
Between
me
ourselves,
to do.
such as to
How could I facilitate that without the school? What do you want me to write down in an order?
in the order that
He even asked for specific language. See, that would have been a good thing for me to take into court, is to have the specific language of what I wanted in the court's order. That's actually a good point that he's making, and that's actually a thing that most people don't think of. When most people go into court, they think, well, the court's going to draft the order. That's the judge's job. And they don't realize that, well, you're actually there not just to win, but to get very specifics as to how you win, as to what you're asking for. And a lot of people don't think of this, but if you just kind of let the court go about preparing the order, they'll often forget to include certain things. They just don't think of all the details the way that the litigant does. And so sometimes you're right, but the court needs to know exactly what it is that you need to move forward. And so, that's a great suggestion by him, but I didn't think to even bring, I doubt that I thought to actually type a very specific language. I doubt that I thought that.
either A, that she leaves my half of the homework in the cubby, or B, that she exchanges the homework to me when I pick him up on Wednesday.
What do you want of those 2
The
options? What do
preferred
you
one
want?
would be to do it on the exchange, because then we both have the whole packet, and it's not. It's
So,
just
okay, so you want the homework packet to go with the child?
with the child, right? And then I
Okay.
could work on it and then give it
What
back
else?
and turn it in. Those 2 things were it. I was going to talk about that case, but you took it down. Thank you. And the mention about paying the school supplies, that's nice that she's paying the uniform, but I also was hoping for help on the tuition. It's only $125. It's not a whole lot. I just don't see why she won't help out with that.
All right, so you want me to order no absences?
Yeah, I like that
You
better.
want me to order that the homework packet go with the child?
Yes.
And you want me to order her to pay half of the tuition?
Yes, please.
And that's it?
And just with her mentioning that the modification prongs weren't there, at the time of filing they were there, and they're not there anymore. I just don't want it to seem like I just filed this case pointlessly and get hit with attorney fees after the fact again. That I just want the court to know that there are affidavits on file from Laura Turner, who keeps the absences. There are affidavits on file from his kindergarten teacher. I want the court to know that if I didn't file this motion, that's where we would be today, with him being ejected from the school. To please not, construe that I just love going to court, and it's because I hate it. I
Okay.
really do.
Your Honor, may I respond?
Of course. I'd like you to respond to his 3 requests.
Okay. On the homework packet going back and forth in between the child, we think that the better response is for Mr. Falcone to receive a homework packet from the teacher, which she's more than willing to do. And the reason is that to have the parents exchange, that's one more point between these parties, that they tried to do that before, and then the homework wasn't getting turned in by Mr. Falcone. So, because the homework wasn't coming back to Ms. Farrar. So rather than ordering the homework packet to go with the child, what we would ask is that both parents get a homework packet from the school, and each one be responsible for turning in the homework on the days that they have Army.
Is homework turned in every day?
Once a week. On Mondays,
Okay,
which is Ms. Farrar's day.
okay.
And when the homework, what was happening before was the homework packet was being passed to Mr. Falcone the way he's talking about, and then the homework wasn't getting done. That's
He
why-
wasn't doing his homework on his
Exactly,
days?
Exactly. And, or else maybe he was doing it and it wasn't getting back to the teacher. So we think in
Well,
order,
I don't understand. She's got the child on Monday. Who's got the child on Monday?
I do.
Ms. Farrar does.
Well, then if he's doing the homework and putting it in the packet, how's it not getting to the
It
teacher?
wasn't getting back.
Always.
He wasn't always doing the homework. It wasn't always getting in the
Is
packet.
that right, sir? You weren't
That is
always doing
not
the
true
homework?
at all. No.
Okay.
So, but we think that the best way of resolving the situation, the school is Miss Alameda is more than happy to do that. it makes a lot of sense to do it that way rather than relying on an exchange to
So
have
what's
that
he supposed to
happen.
do with the homework he does? Put it in his own packet and do what with it?
Well, he can turn it in directly to the teacher
On Monday?
On Friday.
on Friday.
I thought you said it had to be turned in on Monday.
They have a homework, the teacher would accept his homework on, that he has done on Friday.
Okay.
We've already checked with that.
All right, I understand what you want on that.
So the other thing, as far as no absences, I think that what we would ask is just that the court order that the policy of Corral Academy be followed, rather than what the Mr. Falcone wants as a policy. I think that works. I think that when Washoe County School District looked at what was appropriate as far as different kinds of absences, and Coral Academy has their own listing. Let me find it here.
I already know what I'm going to do on this issue.
Okay, well, I believe, Your Honor, that to say that there should be no absences it really goes beyond what should happen in the case.
Okay.
So, and his third issue was
Tuition.
tuition.
Can I answer that? Can I, please?
May I talk to my client just one
Of course.
moment?
I'm more than happy to pay half of it, but that wasn't what you originally
Okay.
stated in here, and I'd be happy to do that, but I'm not going to
Y-
extort
y-
it.
Your Honor, my client is willing to pay half the tuition. That wasn't something that Mr. Falcone asked for in his original order.
Okay, but she's willing to do that prospectively?
Yes.
Okay.
She added
Yes.
it seems that what happens for Mr. Falcone is that he will file these things, and then we're going to settle it, but then I want also this, and then I want also
You
that.
did the same thing, counsel.
And-
You came into the courtroom and said, give me an order about the access of the parties to the courtroom. And it's not fair on either side. Nobody should come into the courtroom and surprise the other side with requests.
my
Could I respond?
one more moment, Your Honor.
So can I just agree to do that and not have it be part of this order? Because I agree that it's not fair for him to bring it up, but I don't have a problem paying it.
Yeah, no, it doesn't matter that it's part of this order.
Okay.
Okay. Your Honor, my client is fine with doing that.
Is there any affirmative relief that you're requesting?
Your Honor, I would be asking for the attorney's fees in this case to prosecute this matter.
Oh my God, she used the same word that she said I wasn't allowed to use. She said she wants to recover fees to prosecute this matter. Does that mean you're a prosecutor now? Kathy Berning, are you now a prosecutor? Is this like seriously? She's such a hypocrite.
I would also be, because basically I believe that we could have resolved this sooner. And I believe that from the onset, that while Mr. Falcone alleges and has alleged in other pleadings that but for his ability to get discovery, he could have proven this case, I would just go on record to tell you I do not believe that is true. I don't believe that he had a substantial change of circumstances at the time that he filed this. And I believe that it was not in Army's best interest at the time that he filed this on October 11th. I do not believe he made a good faith effort in order to resolve this case when only 1 week after filing emailing me that he was intending to file a motion, I said, well, let's get together, sent him an email, and only 1 week later did he file the motion. I don't think that indicates good faith. I think that indicates a person who wants to engage in the legal system, and I think he has shown that to the court by his numerous filings that that's how he chooses to handle this matter.
Okay.
And I would ask the court to deny any motion for change of custody.
I want to try to resolve more than you guys have requested today. In relation to the question of absences, I understand that the school has a policy, and I can't put my policy in favor of the school's policy. But I will tell you that in a contest between parties when they're arguing for a change of custody, I always look at school performance because it's one of the easiest things for a court to do. For parents to stand there and say, he doesn't do this well and she doesn't do this well, that's hard to measure. But I can look at a report card and I can see how many school days the child misses and whether they're mom's days or dad's days, and I can see whether the child's homework is done on mom's days and dad's days. It's an objective measure, and I will tell you that in all cases, including this one, I will look at absences from school in determining what's in the best interest of the child. I expect no days off from school other than illness or emergency. Planned vacations are not a valid reason to miss school days, in my estimation. Let me say that a different way. If I have to choose between two parents and decide one of them should have custody and the other one shouldn't, if there's one parent that does think it's okay to take school days off for vacation and the other one doesn't, that factor would tilt in favor of the parent who doesn't think that it's okay to take the child out of school for vacations. Okay? Now, that's not dispositive. There's a list of factors that the court must consider under NRS 125.480 in determining what's in the best interest of the child, but I'm telling you how I think about it. Okay? I don't think children should be removed from school absent an emergency. The reason we have school is so they go to school.
Your Honor, there is one request that, and I apologize for interrupting the court, that Ms. Farrar, I think, would like to make. I believe that if there's a time where Mr. Falcone is going to be out of town, that rather than placing Army with a babysitter, that Ms. Farrar would ask for a right of first refusal, so that if it's possible, Army can be with parents more than with a babysitter.
All right. On the issue of the homework packet, I think that the packet should travel with the child. If dad doesn't do the homework and doesn't put it in the packet, don't make it up. I want to be able to hear from the teacher that dad's days the homework wasn't done, mom's days the homework wasn't done, mom days the homework was better, dad's days the homework wasn't as good. I want this objective measure. Okay? If one of you is not performing, one of you is not doing the homework, not turning the homework in, not doing it very well, I want to know the answer to that. I don't want to find out when your child's in 4th grade. I want to find out when your child's in 1st grade. So the homework packet travels with the child. Each of you is responsible for the homework on the days that you have the child. On the issue of tuition, you've agreed to split it. That will be prospective only, not retroactive. On the issue of a right of first refusal, I haven't read that in any of the paperwork, and I'm happy to deal with anything that the two of you agree we're going to deal with today, as we just did on the issue of tuition. Sir, do you want to discuss today whether or not you give mom a right of first refusal?
I want to think about it a little bit more just before I rush into that, because once I agree, I'll be stuck to that.
All right. All right, I heard what you said. Okay. I want to talk about the issue of attorney's fees. I want to resolve these here in the courtroom today, if we can do it. It's, I'm sure it's anxiety-provoking for both of you to come here. Any anxiety that the two of you experience isn't good for your child. I want to try to resolve this. Okay, I heard what you asked for in your attorney's fees here today, and I've read what you filed earlier, and at that time you asked for $1,800, as I recall.
I think it was 1,600, Your Honor.
Was it $1,600?
I believe. Let me go back to the document.
I'm just looking at it myself.
Actually, the motion...
$1,687.50.
Right, and that wasn't for this motion, Your Honor. That was for what I had to do as far as the discovery.
I understand.
Okay.
Let me talk about the discovery first. Sir, I've seen your motion for reconsideration.
Right.
It's not submitted to the court for consideration.
Yeah.
Okay, there's been no affidavit, even though the motion ordering that one be submitted was filed 3 weeks ago. I'm very likely, sir, to award these attorney's fees. And the reason is, I told you you didn't have the right to go forward with discovery, and you continued to do it. You filed a motion to compel after I gave you an order that says you can't do any discovery. That's so blatant.
Can I explain it?
Please.
When I first filed the motion, the subpoena ducis tecum, and she filed her opposition, at that point, I hadn't known that there was going to be any problem with subpoenas being blocked.
I understand. My problem is
When
that you
you're-
filed a motion to compel after I gave you an order
was
saying
getting
you
to that.
can't do it.
You filed the order saying that I can't do that, and at that point, when I read the order, I realized it was about the discovery for the mental health records and all that, and then weeks and weeks were coming along, and I wasn't getting the school to help me out with the service on Alicia de Rio, and I didn't know if I was going to get in trouble for not ensuring her appearance here, and then get hit with attorney fees at the trial for failing to get my
You had something that says you can't conduct discovery on the medical bills because you have to seek permission.
Right, and then
you hadn't sought permission on anything, and so you continued to seek discovery on another issue.
Right, and I was going to file a motion to open discovery, but I thought that would just irritate you, because in your order you didn't just block discovery because of failing to comply with NRCP 16.21. You also blocked discovery on the merits. So I didn't want to just file a motion to open discovery when you already said, the rule aside, you also can't do discovery anyway because of all these reasons. And then at that point, I had the whole separate issue with getting that subpoena served. I thought in my head, okay, she didn't object to it. She didn't try to quash it yet. The court didn't quash it sua sponte. Time's running out. What do? I didn't know for sure. So I filed the motion to show cause on Coral, hoping that it would, get things moving along, and it did. I wasn't doing that to annoy you. I really mean it. I
Sir,
wasn't.
I'm not annoyed, okay? There are rules that say you can't conduct discovery. I described them to you in detail. Your obligation, if you choose to represent yourself, is to do it as good as a lawyer could do.
And I'm trying, and if I would have known...
I got
also-
that you're trying, but you're not making it, okay? There's a lawyer in the library across the street every Tuesday night. After you get an order that says, hey, you know what, you can't conduct discovery, and you continue to try to conduct discovery, it's not okay.
But it also didn't even specifically say that. If you don't mind me reading it, this is the other thing that confused me. The part it said...
So this is a judge who's just not listening. And that's because he doesn't want to hear it. He's already got his conclusion made. He's got his mind made up. He already knows what he wants to do. So anytime I try and explain to him, he doesn't care. That's why he keeps trying to speak over me. That's why he keeps interrupting me. The thing about imposing attorney fees as a sanction is that the person's perspective and the person's approach matters. The intent of the filer matters. He's trying to act like it doesn't matter what you're trying to do. You are failing. But that only applies under certain analyses. Like, for example, the prevailing party analysis. So if you win your case, you get attorney fees. It doesn't matter that the other side tried this or that, or their intent was this or that. They lost, you won, you get fees. But when you're trying to impose attorney fees as a sanction, it's different. And the Supreme Court has stated this before. They often reverse these awards. In fact, I will win an appeal on this issue in this case, but it's not with this judge, it's with the next judge. So he's just not listening to me. He doesn't care what I have to say. He already knows what he wants to do. He wants to impose attorney fees because he just wants to make it painful for me to file papers. He thinks that the solution to this problem is to end the filings, which is something I talk about. An end of filings is not end of abuse. And if he doesn't award attorney fees, he thinks in his head that I'm just going to keep filing things. Little does he know, or maybe he should know this because he's a judge, that the point of entering these orders and imposing these things is not to try and manipulate the litigants. It's to follow the law. You shouldn't say, I need to enter this order because I want this specific outcome, from this specific party. You should say, the laws and the facts support the entry of this order. How the parties react is up to them. But you shouldn't concern yourself as a judge and say, I really don't care what the law is. What I care is how this person is going to react after I do a certain thing. That's backwards. It's completely wrong. The other thing that I wanted to mention is, guys, prior to doing this video, I really thought that this judge was a whole lot more obnoxious about this issue than he really was. I'm going to say I think he is obnoxious. He's ignoring me. He's not listening to me. But at the same time, it wasn't as bad as I thought it would be. I kind of had it in my head that this was like I guess on a scale of 1 to 10, with 10 being the most egregious, I thought it would be like a 9. But as I've watched these past few minutes, I think it's more like around a 6. It's bad, but it's not as bad as I originally thought it was. I think he was more fair, especially with a lot of the other issues, than he is with this particular issue. And given the fact that we end up working this out through a settlement, even though I think I could have appealed it and I'm pretty sure I would have won, all things considered, I just want to make it clear to you guys, it was bad, but it wasn't as bad as I thought it was. And you know, one of the things that I think most of these judges don't understand is when you have a litigant who is wealthy enough to afford an attorney, and you have another litigant who is so poor that they can't afford an attorney, I don't think that judges realize just how it almost comes to the point of evil it is to take money from the person who is so poor that they can't afford an attorney and give that money to the person who can afford an attorney. They feel so bad about the person paying money that they seem to forget how it feels to be the person who doesn't have any money. And they're just basically taking money from somebody who already has so little money to fund the other person's litigation. The person who can already afford an attorney, now they get more money. And then you over there, you're so poor, you got to represent yourself. Guess what? I'm going to take your already poor butt, and I'm going to make you more poor. And I'm going to take that money and give it to this person over here who makes 3 times as much. The judges don't seem to get this. I really wish I could say most of them did, but I really don't feel like that's the case. And that might be because the judges themselves make so much money. I think it's something over $200,000 a year. So they might not really understand what it feels like to be in poverty and what it feels like to not really have the money to pay for things like this. These are problems that, in my opinion, it's an egregious situation.
Find it.
The rule by itself says you can't conduct discovery.
No, the rule says without leave of the court,
And you didn't seek it.
And I didn't realize that a motion to order to show cause was a request for discovery. I was just thinking that was going to compel. I guess what I'm saying is if they would have objected to it, I wouldn't have done it.
Let me take this off your shoulders just a little bit.
Yeah.
I'm not inclined to award any attorney's fees for today because the court ordered that there be a hearing.
Right.
So the court found that there was a sufficient basis in your motion to conduct a hearing today. And we're settling this as opposed to litigating it. And there's a line of Supreme Court decisions from the Nevada Supreme Court that says if matters are resolved as opposed to resolved by settlement as opposed to resolved by a determination after litigation, then there's no prevailing party. And it's inappropriate to award attorney's fees on the basis of there being a prevailing party. So I'm not inclined to award attorney's fees for today, although if we leave this courtroom with this unresolved, I'll let them file whatever motion on that they want.
Yeah.
So in my mind, the issue is, well, how about this request for $1,685 from a few weeks ago?
Okay.
And I'm telling you, I told you in writing, in the order, that I'm inclined to grant that.
I have 2 more points.
Wait just a second, sir. I'm disturbed by the fact that it's been 3 weeks and no affidavit has been filed, but the order didn't set a time frame for the filing of an affidavit. So I'm likely to let them go ahead and file their affidavit, and then you can file whatever opposition you want. And if we have to do that, that's fine. I'm here every day. And if I need to be here in this courtroom on this case, it's just as good as being here on another case. But I'm suggesting to you that you might want to agree on a number today and have this over with and not have to come back to court. As opposed to they file their affidavit, you file your response, and I probably schedule another hearing or rule on it on the paperwork, and that, a month and a half from now, 2 months from now, we finally get this resolved. It might be in both parties' interest to just figure out what we're going to do today and do it, and you guys can go away and not have court hanging over your head anymore. Are you interested in that, sir?
I'm very interested in that.
What number would you propose?
Maybe.
I would propose. I need to. What was the number again?
They want $1,685.
Since the court finds my mistake on just NRCP 16.21 and not on all the other issues, I would suppose. Let me see that.
So let me ask you, are you interested in negotiating this to have it be over today, or would you just rather proceed under the rules of civil procedure?
It's up to you. I mean,
Yes, Your Honor, of course, we're willing to
Okay.
do that.
I'm finding.
Is either side willing to cut the number in half and have that be the settlement amount?
No, I was looking more at like a fourth.
Your Honor, I'm not going to settle for a fourth. It was a lot of time and effort.
I would settle to the amount being 1/2 just to block a hearing and you having to bother with it, as long as I still get to appeal whether it was or wasn't a valid award, but at least the
Sir, if
dollar
you settle
amount
it, you don't have any appeal rights after
Okay, then I
you do
don't.
that.
All right, this judge needs to be really careful with what he's doing. He's participating in the settlement negotiations, and he is very close to violating the judicial canons. He is allowed to facilitate settlement, but the comments that he makes are in danger of triggering what the judicial canons call coercing settlement. And if I really honestly think that judges who are presiding over cases shouldn't preside over settlement. In fact, it should just be a judge who's not connected to that case. They call them settlement judges. That's the safest way you can go about this. The judge who's actually got the power to make a ruling, when they participate in settlement negotiations, their comments can very much influence the settlements, the ultimate settlement, and that's not okay, because what it does is it terrifies or scares parties into backing off, not because they feel their case has no merits, but because they feel the judge is going to punish them for not settling. Also, the whole splitting the difference thing and the attorney acting like, oh, well, I'm not going to do it for a quarter, it's a lot of work. She is really, part of me thinks she's not really playing dumb here. Part of me thinks that she really doesn't understand how this works. When you're dealing with a settlement, it's not just, hey, you say this, I say this, and we split it in half. One of the biggest things that goes into settlement is the chance of prevailing. And so it's actually pretty interesting to see myself here, because I'm actually considering an appeal. I've already mentioned it to the judge. And the possibility of winning an appeal influences the amount of the settlement. If I feel like I have a very strong chance of winning the appeal, I'm not going to offer you half. I'm going to offer you a quarter or even less. That's because I think I might win the appeal. If I thought I had a really poor shot, I would offer you more, like 75% or 80%. If I thought it was like a coin toss, a halfway, kind of feel like I do, halfway I don't, then that's more like the 50-50 split. The way the attorney is acting, all like she scoffs and acts like she's indignant, like how dare I? I'm not trying to insult her by offering the low number. I'm trying to compute in my head my probability of success, my probability of prevailing. And since I feel my probability of prevailing is very high, I'm going to offer you a lot less. That's very standard. This is how it works. This is how attorneys settle these giant multi-million-dollar cases. This is why some cases settle for very high dollar amounts and some cases settle for very low dollar amounts. Does anyone honestly think that an attorney can just go in and sue some company for $12 billion and then go to court and say, yeah, let's just split the difference, call it, 6? That's not how it works. The insurance company and the attorney, they're going to gauge how likely it is that they're going to succeed. And if that particular company is like, oh man, we are so screwed, they're going to not offer 6, they're going to offer 9, maybe 10. And if the attorney who's suing them is like, you know what, this is kind of a long shot, they're not going to offer 6, they're going to offer 3 or 2. It's something, but it's a long shot. So this attorney, she just like scoffs and acts like I'm just being unreasonable. I don't know how the judge feels about this. In fact, I haven't seen how this video progresses. But my opinion is that he is going up to the line on coercing settlement, and he's very close to violating the judicial canons. He should be very careful about what he states at this point in time, and he should be especially cautious as to how he presents not only his words but his demeanor towards me when I bring up the possibility of an appeal. Because it isn't appropriate really to talk about appeals when you're in the middle of the case, but it is very appropriate to talk about appeals when you're in settlement negotiations. And so if he, in any way, shape, or form, hints any kind of distaste or displeasure at that, that could be grounds for filing an ethics complaint. And they take it very seriously. That particular judicial canon does not play around. They absolutely 100% do not tolerate judges coercing settlement.
So let me see if I understand correctly what you want to do. It's okay for her to file an affidavit, then you'll do whatever you want to do on your motion for reconsideration, and then I'll rule on it or schedule another hearing in a month and a half or not, and we'll just go from there. That's what you'd like to do?
Yeah, hopefully we don't need a hearing and you can just do it on the pleading.
It's, you know, I can never tell that until I have all the paperwork in front of me. Sometimes hearings are necessary. It depends on how well the issues are covered in the paperwork.
Right. Yeah. I think it's too much just based on that. You didn't see that I messed up on everything, that it was just on the 16.21. I don't see why.
Sir, I could award every dollar that they ask for on that basis alone.
Yeah, I mean, in my opinion, this is tantamount to coercing settlement. If he wasn't retiring, I would probably submit this video to the Commission on Judicial Discipline and have him, or at least try to have him to investigate and sanction him. What he's doing is insinuating that if I don't agree, he's going to award the whole amount. He doesn't say it, but he doesn't have to say it. It's implied, especially with a non-represented party. I mean, even with an attorney, I think it's crossing the line. But with a non-represented party, especially because the non-represented party really doesn't know how any of this stuff works. And it's just a whole lot easier to manipulate and scare a non-represented party if you're a judge. So totally inappropriate. It's so bad.
What if I settle to a half and then that just holds child support in abeyance, that just absorbs child support until it's done? Because I really can't cut a check right now being in school and all
Who's
that.
paying child support to who?
She is. She owes me quite a bit.
That's not true.
That's not true.
Are there any arrears?
Oh, yeah, there are.
No, Your Honor, no, there are not. I have a check that went into the mail to Mr. Falcone, I believe, yesterday.
Oh, I didn't know about that. So maybe they paid up.
Okay. If he agreed on a number, and I don't know what the number would be, I've suggested half, but I'm not proposing it. If it was $1,600 or $800 or a fourth, if it was any number, how much is she paying in ongoing child support?
Like $56 a month.
It's at $56 a month, Your Honor. Based
Okay, so you
upon-
don't want to offset it because the amount that
No.
she owes is so little that if it was $800, for example, it would
Right.
take more than a year
That's correct.
Yeah, and
for the
that's not
offset to
fair
be
her
applicable.
either.
That's right, Your Honor.
I mean,
Sir, based on the amount that she pays, she rejects the idea of using an offset. And you know, when I order monies paid, I never order it over a year. I mean, that's a long time.
It's more, her child support's like 70, and then, never mind, you're probably right. I'm just taking a look at the details.
70.
I don't want to be too heavy-handed in this. I suggested to both of you that you consider a half. If that's unacceptable to either party, then we're done, and you guys can proceed under the rules of civil procedure. If you want to settle it, we can settle it right now. If that's not advisable, if it's not appropriate for either side, then we don't need to. We'll just proceed
Yeah.
under the rules of civil procedure.
Your Honor, the last thing that Ms. Farrar wants is to be litigious, nor I. And I am willing to settle, but I'm not willing to settle and then have Mr. Falcone try to preserve some rights to appeal what we've settled to. I think then it just creates more attorney's fees for my client. Likely I would get those attorney's fees in the end, but it just
So
perpetuates
let me see
the
if I
process.
understand what you're saying. That you're happy to settle this for some number if, in addition to the number, you work out payment terms that are acceptable to you, and he waives any appeal right that he might have.
That's correct.
Okay.
As
Do you-
long as the payment can be made within a period of 1 year,
Okay.
which I think is more than generous.
Sir, that's where they are, and you can say yes, or you can say no, or you can make a counter proposal.
I'm gonna take a really quick look at, because she had a little list of what I was being charged for. I just wanted to try and find it. But I am willing to end it today. I really don't want to file appeals willy-nilly and do all kinds of crazy things. And I'm just frustrated, that's all.
Well, I thought we were going to be battling for 2 hours, and it looks like we're going to be done in one.
I'm
So
trying
there
to-
are some advantages of what we're doing here today. And sir, if you need to step out to look at your paperwork, if you're frustrated here in the courtroom, take a moment and compose yourself.
Can I talk to Kathy for just 2 minutes? Or
Who's Kathy?
her attorney.
I have no objection if the two of you want to talk. I mean, you're both the counsel in the case. I don't object to it.
Your Honor, I'm concerned with speaking with a pro per. That's, if there's a question I can answer, but I'd rather have negotiation with having Ms.
All right, well, if it's settlement discussion, sir, if what you're saying is you'd like to go off the record, we could do that. If you guys want to have some settlement discussion, you can do it right here in front of me.
Really quickly, just for 2 minutes.
Is that acceptable?
Yeah, but he should call you Miss Bernie.
Hey guys, so it's true that I should call her Ms. Berning. In fact, I should probably call my ex Ms. Farrar instead of Monica. But it's odd that my ex is obsessing about that, and it's obvious that I didn't do that on purpose. In fact, you know, when you're 20, whatever, I don't know how old I was back then, 25 or 6 or something, you just don't think in those terms. Like, that's grown-up speak more. I don't know. I'm just bothered a little bit by the fact that my ex got all up in arms about that, because we're dealing with, you know, pretty serious stuff here in court, and the labels, it's not really that serious. Again, guys, you should do that. Definitely don't call your opponent or your opponent's attorney by their first name. But I mean, that's not something that I knew, so it's not like I was trying to mess with anyone or insult anyone. Yeah, odd.
Yeah, that's acceptable.
All right, let's go off the record. All right, so we'll go back on the record in just a minute, and we'll do this. And this is my understanding of what we're going to say. That the homework pack goes with the child, that you're going to split the tuition prospectively, that the issue of attorney's fees is resolved by the payment from father to mother's attorney, $625, $650 over the next 3 months.
Just to clarify, to avoid any confusion, that's not $650 every month for 3 months. That's a total of $650 after 3 months. So it came to like $200 something per month, something like that. And the first month or two was knocked out by the child support arrearages that she owed me. So I only had to pay that third check, which came out to like $100 and something.
And that any appeal rights which father or mother might have in relation to the resolution of the issues pending before the court are waived, which would mean that the motion for reconsideration is withdrawn, that you're not going to file anything else for attorney's fees, that you guys walk out of the courtroom today, and as of today, everything is over. Is that right?
Yeah, that's good.
That is correct, Your Honor.
Okay. Let's go back on the record, please. Okay. We're back on the record. Ms. Berning, would you please, the parties have reached some agreement, would you please place on the record what the agreement of the parties is, and then, sir, you'll have an opportunity to comment and make sure that she's stated it correctly.
Okay. Your Honor, do you mean for the whole case or for the matter of attorney's fees alone?
I would hope that you would place on the record a resolution of all issues
Thank you.
that exist between these parties at the present time.
Thank you. Your Honor, it's my understanding that the parties have resolved the matter such that there will be no change in custody, that the portion of Mr. Falcone's motion with regard to custody is denied by the court, that custody will remain the same as joint legal custody, that the court has ordered that absences are an integral part of school performance, and that because of that there will be no absences, that the minor child will have no absences for anything other than illness or emergency?
Let me just
Is that-
change that. That's not really an order. I just indicated that
Okay.
that in making custody determinations,
Oh, okay.
I look at it that way, that I favor parents in making
Okay.
custody determinations who get children to school more regularly than parents who don't get
Okay.
children
So-
to school as regularly.
Okay, so that if I could, if after the denial of the motion for change of custody, that the homework packet would travel with the child, and that the each parent is responsible for their own homework, and that if one parent does not do the homework, the other parent is not to make the homework up with the child. And that tuition is split between the parties prospectively. With regard to the issue of attorney's fees that's pending in this court, that the parties have agreed to settle for Mr. Falcone to pay attorney's fees in the amount of $650 over a period of 3 months' time. That there be that any appeal rights between the parties on this issue is waived, and that on this basis, Mr. Falcone's motion for reconsideration is withdrawn.
Sir, has she completely and accurately stated the agreement, or is there more or something you'd like to tinker with? Or?
That sounds like the agreement.
Okay. Then the court will sign that order when it comes to the court. You'll prepare the order,
Quickly.
please?
Yes, Your Honor.
Okay. Is there anything else anybody would like to discuss?
No.
No, Your Honor.
Good
Thank you
luck
for
to you
your
both.
time.
How's your boy doing?
Really good.
He's 6 years old?
Yeah,
He's in
doing-
kindergarten?
He's in kindergarten. He's so social. He's so happy. He's so carefree. It's just amazing. Even when two parents can't agree, the child can still benefit from both of us being in his life.
Here's what happens. If you two can't agree, it impacts him, but you don't see it yet. You see it when he's 12, 13, 14, 15 years old. That's when it comes out. You got to cut this squabbling out if you want to have a child that's going to be a happy child, that will stay a happy child. You can build division into him so he doesn't know which end is up. He loves both of you.
I think he is very right about this. He said the thing that made the most sense is that he doesn't know which end is up. And even though superficially he was acting positive and joyful, that didn't necessarily mean he was acting that way when he was in school. As I mentioned earlier in the video, he wasn't doing well in school, and he wouldn't do. It just continued on for years. The D's and F's and all that stuff continued and continued until her parental rights were terminated. And also, like when a sitter was watching him, and I don't even know how he was in her custody, but even when he was in my custody and he was acting happy, back then to me, it seemed like he was a normal kid with two parents who couldn't agree. And of course, back then, I kind of assumed that separations were like this. It took me some time to realize that our separation was not normal. And then the other thing that I wanted to mention is I figured out over the course of time that our son sort of had this part of his brain that just distracted him from life. And so superficially he'd look joyful and he'd play around with stuff and he would talk to people, not always look him in the eyes. That was one of the weird things. But it was like the judge said, it's like he won't know which end is up. What it's like a brain, he was always in a brain fog, and you couldn't really get any depth to him. You couldn't get into any deep games. You couldn't get into any deep conversations, and that's something that you can't tell when a child is so young. But as he got older, it was very clear that he seemed like that he was just a shell, and that the inside of him, you couldn't get to it. It was either locked away or missing or in chaos. And everything that the judge is saying there is true. And of course, at that time, I naively thought that we'd be able to eventually work things out. And in fact, it's going to take quite a while. I'm still not. Maybe I'm halfway there. But he says, he says it like we just both need to figure it out, and he doesn't realize, and even I don't really realize that my ex doesn't want to figure it out. It's not just that we can't agree. By design, she won't agree. She needs the conflict to continue. This is going to become more obvious as time continues, you're going to see more filings, you're going to see more hearings. This isn't over yet. But the judge was very insightful there in his comments, and I think generally something like that would be good advice for most families. But that is not something that's going to work with when you have a case that involves abnormal psychology issues. That just, everything is different in those sorts of cases, and child protection needs to prevail over parental rights in those cases.
You know, if you two are fighting, he doesn't understand how that can be, and it literally tears him apart. I wish you good luck.
Thank you.
Thank you, Ellen, for your time.
Just one quick document to go over. Here we have the minutes of the court. I'm not going to spend too much time reviewing the minutes. It basically summarizes the court's order. It summarizes some of the discussions in the hearing. I'm going to spend a lot more time on this, guys, when we get to the court's final order. And at that point in time, I'll go through the order line by line. But as with my previous videos, you can always go down to the description below, click on the link, download the minutes for yourself, take a look, and if you have any questions, feel free to post those questions down in the comments below. Going into the aftermath, I didn't file anything, so I incurred $0 in costs. My ex's attorney didn't file anything either, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. And my ex would have probably spent at least 1 hour of prep time with her attorney. They were at the hearing for an hour and a half, if you count a little bit extra for that settlement negotiation that we went off record for. So that comes to 2.5 hours. And then of course the waiting. There's probably a little bit of waiting in the waiting room prior. An additional half hour, I think, there's reasonable. That should take my ex attorney fees to 3 hours at the rate of $250 an hour. That comes to $750 in attorney fees. I know that the judge ordered me to pay her attorney fees, but the way that we have been doing these fees has been sort of the conservative approach. The amounts that are owed in actuality, I think, are inflated by about double. And these amounts that I have to pay are coming from fees that were already paid by my ex. So rather than take $650 out of my ex's attorney fees, I'm going to just go ahead and add $650 to my side to sort of represent the attorney fees that I paid for her. But I'm going to still leave her side at $750 an hour, because I think that's just more in line with the approach that we've been taking, where I always tend to err on the low side with the amounts that I'm putting up there. It makes more sense to add the $650 to what's already been sort of computed in these side panels than it does to take away. That's just, I mean, guys, these numbers are ballpark anyway, so I think it reflects my additional expenses, and I don't think it takes away from her expenses, which are already on the light end anyway. It's going to be more accurate to just leave hers the way they are. So all that being said, $750 in attorney fees for my ex and $650 for me. And I think at this point in time, we can go ahead and I'll sign off. If you have any questions, feel free to post it down in the comments below, and I will see you guys next time.